Hello everybody, I am S. Kandasamy. In this video we are going to see Right to Information Act 2005. Right to Information, popularly known as RTI, is a fundamental right given by our Constitution under Article 19.1. The Article 19.1 says that every citizen has freedom of speech and expression. In 1976, the Supreme Court said that people couldn't speak or express themselves unless they know. Therefore, the right to information is embedded in Article 19.1 and is a fundamental right. In the same case, court also said that India is a democracy and people are the masters. Therefore, the masters or the people have a right to know how the government means to serve them are functioning. Further, every citizen pays taxes. The citizens therefore have a right to know how the money was being spent. Enactment of RTI. The RTI Act was enacted in 2005. It was passed in Lok Sabha on 11th of May 2005 and on 12th May of Rajya Sabha by the UPA government. It received the assent of President of India on 15th June 2005. Soon after 120 days, the Act came into force on 12th October 2005. The objective of the Act was revolutionary because it opened all official departments across the country to public scrutiny. Background of Right to Information Act 2005. Asking question is a human tendency. The great philosopher Socrates said, until unless you ask questions, you cannot get the answers. The RTI is all about asking questions and getting answers as a right. Because our Indian government retained the Colonial Official Secrets Act (OSA) of the British era even after independence and continued to operate in a secret manner. At an administrative level, the Central Civil Service Conduct Rules of 1964 also strengthened the OSA by prohibiting the government servants from communicating the official document to anyone without authorization. Two features that make RTI a unique act. It was a right-based enactment. The right to information is a right-based enactment done by the Government of India. The act or laws that provide specific right to the citizens are called a rights-based enactment. The UPA government has enforced several right-based enactments in their tenure. For example, Right to Employment, Mandarega 2005, Right to Information Act 2005, Forest Rights Act 2006, Right to Education became operational in 2009. These are the examples of rights-based enactment. The second feature is enacted due to the pressure of society. The Act was a few of those acts which were enacted with the active involvement of society and pressure groups. For example, the Lokpal Act of 2013 was passed by the government due to the heavy demands of the people and pressure groups. Similarly, the government passed RTI due to its demand right from the beginning. Way back in 1986, in a Supreme Court judgment, the court said right to information is an essential part of freedom of speech and expression under Article 19.1. Since then, the successive governments started promising to bring the RTI Act, but the UPA government in 2004 decided to bring it. Finally, it involved all the experts from the field such as Aruna Rai, ex-IAS and others to give their suggestions on the draft of the new Right to Information Act. You may wonder who started RTA Act in India. RTA Act came into force on 12th October 2005. There are only two schedules in RTA Act 2005. Mazdoor Kisan Shakti Sangathan is the organization that was instrumental in the passage of the RTA Act. The first RTA application in India was submitted by Shahid Raza Bani. What information means under Right to Information Act? Information is any material in any form. It includes records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form. The objective of this RTA Act is to give public the authority to ask questions about how government machinery works, to encourage effectiveness and accountability in government activities, to control fraud, as well as to enable democracy to function for our residents. The primary goal is to empower citizens, promote openness and accountability in government operations, combat corruption, and make our democracy truly function for the people. It also empowers every citizen to seek any information from the government, inspect any government documents, and seek certified photocopies thereof. RTA empowers citizens to officially inspect any government work or to take the sample of material used in any work. What's the public authority? It means a body or institution of self-government established or constituted under the constitution, law made by the Parliament of State Legislative by notification of the government, body controlled or financed by the government, non-government body directly or indirectly funded by the government. Procedure to apply for an RTA application. RTA can be claimed through two means. First, through in-writing mode or through electronic mode. Regarding format of application, there is no prescribed format. Application can be made on a plain paper with the details of the sender and the public information officer and the information seeking. Regarding reason, there is no need to specify the reason. About language, you can write in Hindi or in English or any official language of the area you seek information. About fees, the fees required should always be reasonable and 10 rupees code stamp is enough. If extra fees are required to produce the information, then the same must be intimated in writing with the calculation details of how the figure has arrived. Normally, a person has to wait for receiving the information is of 30 days from the date of application to receive the information. But if the matter is related to life and liberty, the time limit for the public information officer to provide information is 48 hours. If the interest of the third party is involved, 40 days. Failure to provide information within the specified period is deemed refusal. If you don't receive any information to whom you have sent or any incorrect information received, then you should write to the appellate authority within 30 days from the date of receipt of the reply. This is the first appeal, and the second appeal will be to the Information Commission. The Commission will decide what punishment is to be given to the concerned authority for not fulfilling the desires of the individual. Like, subscribe and share. Thanks for watching.